California. Hear ye, hear ye, hear ye. The Honorable Supreme Court, sitting in bond, is now in session. Please be seated.
Good afternoon, ladies and gentlemen. The clerk may call the calendar.
Good afternoon. Supreme Court of California. Here for arguments in Los Angeles on Tuesday, June 5th, 2002 p.m. Case number S237801. Anyway, C.K., the person dying under the juvenile court law, the people plaintiff or respondent versus C.G., defendant and felon. The consolidated matter, case number S237762. Anyway, C.K., the person dying under the juvenile court law, the people plaintiff or respondent versus C.H., defendant and felon. For a felon, Ms. Anne Margaret Camier.
Ready.
And for respondent, Ms. A. Council. Case number S241434, Eduardo de la Torre et al., plaintiff and appellant versus Cash Call, Inc., defendant or respondent. For appellant, Mr. James C. Goodland.
Ready.
And for respondent, Mr. W. Selby.
Ready.
Good afternoon, ladies and gentlemen. It is my unhappy obligation to inform you that the Chief Justice is not with us because her mother passed away last evening. We thank counsel for your accommodations, and we will carry on. We know that you will all keep the Chief and her family in your good thoughts. For the first case, we are joined happily by the Honorable William J. Murray, Jr., Associate Justice of Division 3. Counsel, you may proceed.
May it please the Court, Ann Mania, counsel for petitioners CB and CH. Since well before 2004, the law in California has been that people convicted of misdemeanors are not required to submit DNA to the state's DNA database. Even with the expansion of DNA collection enacted in 2004 under Proposition 69, the overwhelming majority of misdemeanants do not have to submit DNA to the state's DNA database. In 2014, as the Court is well aware, Proposition 47 identified 6 offenses that had formerly been felonies and said, we're going to treat these as misdemeanors, and we're going to make these misdemeanors as a matter of law going forward. And it wasn't just that these would be misdemeanors going forward. Proposition 47 created mechanisms by which people such as CB and CH could petition the court to have their offense changed from a felony to a misdemeanor. And throughout this process, again, Penal Code Section 296 has said that misdemeanants do not have to provide a DNA sample to the state's DNA database.
So, counsel, there is no dispute here that your client's DNA was lawfully collected at the time?
Correct.
Okay, so the only question is not one of collection, it's one of expungement. Is that
Correct.
Right. So maybe you could point us to the relevant authorities there.
Proposition 47 clearly stated that reclassified offenses should be considered misdemeanors for all purposes except one, and that's gun possession. So under this canon of statutory interpretation, expressio uno est exclusio alterius, that was
Very good.
I practiced. That was an instruction to the legislature and to the electorate not to create additional exceptions to the misdemeanor treatment of reclassified felonies. So under the logic of Proposition 47, under the basic simple reasoning, these people have been moved into a category where they are not required to have a DNA sample in the state's DNA database. Therefore, in order to enact the purpose and the intent of Proposition 47, they should be entitled to expungement.
Counsel, do you find anything in the expungement provisions of the statute that governs DNA collection and expungement that supports your argument, or is the argument entirely founded on whatever we can find in Prop 47?
It is primarily founded in what is in Prop 47, but I would also call the court's attention to the circumstances in Penal Code Section 299B, so Section 299A says that you're entitled to expungement if you no longer have an offense qualifying for DNA submission. Subdivision B lists the circumstances under which somebody can petition for expungement. And I think it's important to keep in mind that even under Section 299B, you can ask for it. The court has the discretion to deny it. Under subdivisions B2 and B4, a person is allowed to petition for expungement if their underlying conviction has been reversed. That's B2. And under B4, if they've been found not guilty or acquitted of the underlying offense. It is difficult to understand how this situation is not analogous to that. For example, if on appeal somebody appealed a felony, they claimed there was not substantial evidence to support that conviction, the court agreed with that argument but said there is substantial evidence to support a finding of a lesser included offense that's a misdemeanor. That felony conviction has been reversed on appeal. They are no longer required.
I think that's all true. That's all true. But the problem here is that the problem, I think, for your position is that the statute doesn't really cover this situation. 299B doesn't really cover it. That's why you're making analogies, because it actually doesn't cover it. What are we supposed to do with that? I mean, what is our role here? Are you asking us to gap fill? Are you asking us to use our inherent authority? What are you pointing us to as the basis for authorizing an expungement in this instance? Is it a constitutional argument? I mean, what is the nature of your claim? Because it's not really in the statute. Are you asking us to read the statute to interpret B2 or 4 to cover this situation?
I'm asking the court to recognize that, as stated in Coffey and Alejandro N., that 299B is not and 299A are not the exclusive mechanisms by which somebody can be entitled to expungement. And
if those are not the exhaustive provisions, then what else are we supposed to look to?
the intent of Proposition 47, which is, and specifically Section 1170.18K, which says that these offenses are to be treated as misdemeanors for all purposes, under the plain language of Section 290.
But is there not I hear that argument now, and I read it in the briefs, and I think there's, it goes as far as it goes. But I just wonder how you might, what would be how do you want us to read the statute, Prop 47, so that we can get to the following point, which is where I think you need us to get to, and that is to not draw a distinction between collection and expungement, right? Because there's something about the way the statutory scheme works that applies to collection, and then there are these different provisions that apply to expungement, and I think, unless you tell me otherwise, that your argument is sort of predicated on us really not drawing a distinction between those two categories.
To a certain extent, yes, and a reading of both the plain language of Section 299A, which says if you don't have you no longer have a qualifying offense, you are entitled to expungement. And Proposition 47, independently of 299,
So, just trying to reason through that argument. So I guess your answer to Justice Liu's earlier question is, if you have relief under Prop 47, you no longer have a qualifying offense.
Correct.
Okay.
I'm sorry, I wasn't clear.
All right. It's helpful. I think,
Okay.
we're trying to square the circle here in some ways.
So, and it's our position that that is an appropriate choice for this court to make in light of the broadly remedial nature of Proposition 47. It mandates reclassification going forward. It enables reclassification for people who are serving terms right now, and it goes further than that. It says Respondent makes much of the fact that the purpose of Proposition 47 is public safety and saving money. So even for the set of people such as CB, who they're done, they've been adjudicated, they're out of the system, they're not costing the state any money, absent some independent subsequent offense, and we have no evidence that either of these gentlemen have this independent subsequent offense. They're not involved in the criminal justice system. Even they can apply for reclassification, and the only conceivable reason to do that would be to relieve them of the collateral consequences of having a felony offense on their record. One of the collateral consequences of having a felony offense on their record is that they have their DNA in the state's DNA databank. And Respondent also makes much of the fact that that's not terribly harmful, but as this court recognized in Booza, DNA contains a wealth of very, very private information, from ethnicity to parentage to propensities. And to say that there is no harm in having that information in a state-run database, I think, underestimates the...
Can I ask you about that? So are you invoking constitutional privacy concerns here? I'm still trying to get a clear sense of what the legal architecture of your argument is. I think you make several good points, but I can't figure out if what you're making are essentially policy points or what the legal hook is for your argument.
The legal architecture for the argument is that Proposition 47 and Subdivision K of 1170.18 say that these reclassified offenses should be considered misdemeanors for all purposes except one.
I grant you that. Okay, so that takes us so far as to say that, that even takes you so far as to say that under 299A, perhaps, the petitioners here they don't have a qualifying offense anymore, right? But still, the problem here is that the statute elaborates a set of procedural mechanisms by which a person obtains expungement. It's not just that Subdivision A is a standalone expungement provisions. You still have to follow the rubric of what follows in B. And so I guess I would just say keep going then. So you have established there's not a qualifying offense. Then what? I mean, where are the procedures, in other words, to get your clients the relief that they seek? Where in the statute do we find the procedures authorizing this?
At this point in time, the way the statutory scheme is laid out, it would have to be by analogy to the circumstances in 299B. But to say that because there is not a statute that enables somebody to be relieved of the collateral consequence, this specific collateral consequence of having a reclassified offense.
Let me ask you this. Okay, so let me put it this way. Suppose we rule for you and we issue an order, right, from a court that says expungement, you're entitled. What is the next petitioner supposed to do? Does every petitioner in the same shoes as yours then has to come to court, get a court order of this variety, and then they would be entitled to expungement? Is that the idea?
If the state opts not to create a more streamlined and less costly procedure, then that may be what they have. But that's really what they still have to do under 299B. They have to get an order from the court that says they meet one of those 4 criteria. They have to give that order to the AG.
So I take it from your answer, you agree that your client does not qualify under any of the 4 paragraphs in B.
No, I would have to say but he is in an analogous status. And to say
But based on the language in each of those paragraphs, you would agree that your client does not qualify. So we would have to read something else into the statute. And what would you have us read into it?
I don't know that you would need to read something into the statute. I think there would need to be a finding that CB and CH are entitled to expungement as because it is mandated by the language of Proposition 47. And, I mean, there are a number of orders that are requested in the criminal world that are named after cases. I mean, you could file a CB request, and the state could set up a procedure.
So
but to say that...
I'm sorry, but it sounds like then, I may have misheard you, because I thought you were arguing that 299 does cover the situation, given that Prop 47 changes the underlying offense, that you were making an argument about how that is analogous enough to what's in 299 that 299 applies.
It's our position that 299A applies by its plain language, and then 299B contains provisions that are analogous to this.
And so, okay, let's stick with 299A. So by its plain language, just walk us through that argument.
So by its plain language, 299A states that if somebody has no past or present offense or pending charge which qualifies that person for inclusion within the state's DNA and forensic identification database, and there's otherwise no legal basis for retaining the specimen.
Why doesn't the term past offense cut against the argument that I think you're making? Because in other words, if somebody had an offense that was a felony at the time, and it's no longer a felony because they've obtained relief under Prop 47, it's still a past offense, presumably.
It is a past offense, and Proposition 47 has mandated that it be considered a misdemeanor for all purposes, that it's changed to a misdemeanor. So they no longer have that qualifying offense.
So what you're suggesting is that Prop 47 impliedly amended Section 299 to create what is in effect a sort of fifth basis on which a person can seek expungement under Subdivision B. Is that an accurate summary?
I think that's an accurate statement. I'm troubled by the idea that if Proposition 47 mandates that expungement, or if an interpretation of Proposition 47 is that expungement is appropriate because these people no longer have an offense qualifying for, that would enable the state to take their DNA. The lack of a specific procedure in 299B for that expungement basically nullifies the intent of Proposition 47 and the clear intent. So yes, actually coming back to your question, I would agree that implicitly there is now another category in Section 299.
Isn't that kind of a heavy lift in the sense of the form of your argument, which is that in answer now to Justice Kruger and to Justice Chin, you've essentially said, please rewrite the statute to add a fifth element where none currently exists. It would seem to me that the nature of your argument, when you say that the basis you're urging, I don't think you're wrong to urge this. I mean, you have a good argument, but the basis you're urging is by analogy based on a sameness, right, a similarity. That sounds like equal protection. What you're saying is that the legislature here has omitted a category which it would not make any sense to omit, and thus these people are being treated differently from people who should be treated, in the correct way under the statute, and this is an irrationality in the statute. Why isn't that the better argument here? Instead of asking us to essentially amend the statute or read the statute in a way that it just clearly doesn't say.
I will defer to that argument.
Well, I'm wondering why, are you pressing that argument with us? The equal protection argument.
The equal protection argument as framed in the briefing was a temporal argument, which is that people who are convicted of these offenses going forward are in a different position vis-a-vis DNA sampling than people in the past. But I think it is equally applicable to folks who are eligible for expungement under Section 299B. And again, they are not really functionally any different. So yes, I would advance.
And what would the standard of review be under an equal protection argument? Are we talking about rational basis scrutiny? Are we talking about some sort of heightened scrutiny? What are we talking about?
My initial position would be that because privacy is implicated in the collection of DNA, as discussed in Booza, particularly in the dissent, that it would be a strict scrutiny analysis.
Now, if that were the case, why would you raise that argument via the Equal Protection Clause as opposed to bringing a challenge under the Constitution's privacy provision? What is the difference, in other words, between those two challenges?
Well, as a preliminary matter, neither was raised in the court below. So can I ask you to repeat your question?
Well, if your argument, I had understood the argument in the briefing to assume that rational basis applied. It is, I think, a different argument to say that because privacy is implicated, strict scrutiny applies. And if that's the case, and assuming we can go back and look at the briefs and look at the arguments made below and see whether that argument was preserved, but if it was, I'm wondering why would we analyze that issue, essentially review the privacy implications of the distinction via the Equal Protection Clause as opposed to just reviewing it as a matter of the Constitution's privacy protection, the more specific provision protecting privacy.
So two answers. One, I mean, in the interest of full disclosure, this is not an argument that we developed in the courts below. I would say because of the privacy implications. Circling back, even under rational basis, if preserving the integrity of the DNA database, which is what Respondent asserts as the rational basis for maintaining DNA samples, both for people who've been convicted of these offenses in the past, if preserving the integrity of that database were truly a legitimate state interest, why has Penal Code Section 296 not been amended to require misdemeanants to contribute DNA samples to the database? If it is so essential to the integrity of the database, then one would have expected that we require that misdemeanants contribute their DNA or provide a DNA sample to the state's database.
I don't follow the logic of that argument. Is it not a legitimate policy? I'm troubled by the use of the term the integrity of the database. Excluding some DNA donors from the pool of people who are in the database doesn't undermine the confidence in the integrity of the database, just makes the database smaller.
Correct. No, I agree with that.
Okay, thank you.
I am at the end of my time.
Yes, you are, but you have 5 minutes for rebuttal.
Good afternoon, may it please the court. In passing Proposition 47, voters looked to make neighborhoods safer from recidivist crime through education and treatment programs funded by savings from shorter sentences for low-level offenses. It's not reasonable to assume that voters also intended to eviscerate core components of the state's DNA Act, passed as Proposition 69, which is California's most effective program for keeping neighborhoods safe from recidivist crime.
Is there any reason, any rationale for why you would treat misdemeanants going forward differently than the misdemeanants, now reclassified misdemeanants, whose DNA has already been gathered?
Well, the fact that a sentence has been reduced or reclassified doesn't impact the state's interest in retaining the best identification information that it has for identifying recidivist offenders. So it's not a question of we're not interested anymore in having that information.
But that's the very same interest that could be asserted for people who engage in the exact same conduct prospectively. I mean, we're talking about equivalent conduct now classified as a misdemeanor committed in the past, previously a felony, now reclassified as a misdemeanor, and you're saying for the one, there isn't any such interest in policing recidivism, and then for the other there is?
No, it's not a question of policing recidivism for one class rather than another class. I mean, what happens under the Database Act is there's a different standard for collection and retention. Collection refers to the felony convictions or adjudications, and retention is a lot broader than that once the samples are collected.
But let me get at this question and perhaps just use slightly different words. So the legislature has taken, or the people have taken an offense that is exactly the same offense, but the label is now misdemeanor instead of felony. And the consequences that follow from committing that offense prospectively are different. So what is the policy logic that justifies treating two people who have committed the exact same offense differently on the basis of that decision to label it a misdemeanor rather than a felony now and to punish it differently?
Well, that basically does implicate the Equal Protection Clause at that point, where you're looking at two classes of people, and they're not similarly situated because one has committed a felony under the law, and the other one has committed a misdemeanor. In addition to that, the state continues to have an interest in solving recidivist crimes, whether it is from a felony offender or from a misdemeanor offender, and that also advances the purpose of the DNA database as a whole, which is based on the idea that the majority of criminal offenses are committed by persons with prior convictions for low-level crimes, and that was really kind of a breakthrough part.
I guess I'm still not really understanding
69.
the nature of the argument. I mean, the interest in retaining this DNA as a safeguard against, you perhaps don't like the words policing recidivism, but in any event, there's some sort of surveillance aspect that is served by retaining the DNA. Why is it rational to have that state interest with respect to people who engaged in the exact same conduct at time one, but then not apply that equally to the people who engaged in the same conduct at time two? What differentiates these two? It just seems opportunistic, which is to say, by accident of the fact that it was classified as a felony at time one, you have the DNA. But the exact same conduct now is being called a misdemeanor at time two. But that doesn't affect the nature of the state interest involved because they are it's the same category of conduct. The people involved are not relevantly different in any way, unless you tell me otherwise.
Well, people made a distinction in who was collected at felony conviction and then who was retained. And so that distinction remains regardless of Proposition 47. The database is filled with people who had their sentence reduced under Section 17 and are misdemeanants, and yet they qualify for retention based on the state's interest in solving recidivist crime and having the best identification.
Do those individuals, just assume with me for a second, we're talking about the class of individuals who are entitled to resentencing, or to reclassification at least, under Prop 47. Do those individuals who were convicted at time one pose any greater risk of recidivism than the people engaged in the exact same conduct at time two?
They pose an equivalent risk of recidivism.
So why are they being treated differently?
They're treated differently because the class of collection is greater than the class of retention, or retention, is greater than the class of collection. And so that's just the cutoff for the DNA database law, which is aimed at addressing recidivist crime and keeping neighborhoods safe. And in fact, the state's DNA studies have shown that that the majority of violent crime is committed by individuals who have committed low-level crimes. They're not committed by persons who are arrested for, other rape, robberies, or murder. So it was the theory of Proposition 69, and it is also the reality that we see in examining our data from the DNA database program. So the interest is in retention.
Is one possible version of an argument that you're making or could make that the legislative body here could reasonably conclude that the risk of recidivism is greater for those who were punished and convicted of a felony at the time than those who were punished and convicted under a set of laws that punished equivalent conduct, but that treated that conduct as a misdemeanor from the outset? In other words, is there a reasonable basis to believe that there is a greater risk of recidivism for those who violated or knowingly violated laws that established felonies as opposed to misdemeanors at the time the crime was committed, punished, and the convictions were entered?
Yes, well, those individuals aren't similarly situated in terms of, one group has committed a felony and is punished according to that set of circumstances, and the other has committed a misdemeanor as it's redefined in Proposition 47. So they're not exactly similarly situated, but the bigger interest is that the state has this interest in retaining the best identification information that it has for its criminal history records. So you want to have accurate crime solving. You want to have accurate identification. You want to make sure that innocent persons aren't needlessly investigated for crimes they didn't commit. And so the purpose of the database in retaining these samples enables the state to have the best identification program for DNA that it can. So in that sense, the samples, that's the idea behind the DNA sample retention.
Your friend on the other side seems to argue that under 229B, her clients do not qualify under any of those 4 subsections, but they could qualify under A, no past or present offense or pending charge. What is your response?
I think that it's important to read the statute as a whole. So collection is set forth in Article 2 of the DNA database, who, what, where, why, how, and when of collection. Expungement is set forth separately in Article 5, and there is only one section in Article 5, and that's 299, and it has several subdivisions, all that deal with the only subject of Article 5, which is expungement. And so what you see, from the structure of the Act is that B defines A refers to B defines the criteria. For convicted and adjudicated offenders, there are only 3 criteria: reversal with dismissal, and C adds that the trial court has to find that there's no appeal pending. The court can find an individual factually innocent, or there's an acquittal. So those are the only circumstances, and they're set forth clearly in B, and those circumstances do not include the situation that appellants are in here. And moreover, it's not only that those are the three situations for convicted and adjudicated offenders. You also have to have no other legal basis. There also has to be no other legal basis for retaining your sample in the DNA database.
So can I ask you about that? At a statutory level, right, the other side argues here that after the reclassification, there is no longer a present or past offense that qualifies the petitioners for inclusion in the database. Do you disagree with that?
Yes, I disagree that there is still a past qualifying offense, but even B is further clarified in F. And F makes it very clear that notwithstanding any other provision of law, including Section 17 or 1203 or 1203.4, and now 1170.18, after the legislature clarified it further after Prop 47, a court is not authorized to relieve a person of the separate administrative duty that a person has to provide samples after a felony conviction or adjudication. So, in other words, the DNA Act has a mandatory duty with respect to DNA samples, and that is a separate administrative duty. That's the language of the statute, and that's apart from the punishment aspect of the of the law itself. I mean, so it's looking at this as a separate administrative duty on an identification basis that's unrelated to punishment, and that's what the expungement
What do you
section is
think then
looking
the
at.
phrase "for all purposes" in Prop 47 means then?
Well,
If it doesn't mean this, if it doesn't change a past offense, the characteristic of a past offense that previously qualified the individual for collection and then inclusion in the DNA database, such that it no longer does, then what does it mean?
well, in order for the misdemeanor for all purposes language, except for the firearms possession, makes sense because in order to be an exception to something, you need to have an entitlement to it in the first place. So once an individual's status is changed from a felon to a misdemeanor, they're no longer going to be a felon in possession. So if you want to preserve that public safety component of essentially the Section 17 type of resentencing, you're going to have to make an exception to that entitlement in Proposition 47. The situation with DNA is completely different. There is no present entitlement to expungement under the law. You won't have to accept something that's already accepted. Notwithstanding any other provision of law in F, when there's a sentence reduction, you don't get sample expungement. So you wouldn't have to accept it you wouldn't even have to mention it in 47. That's not what voters would have presumed anyway. I mean, first there's legislative silence completely. Not one mention in 47 of anything having to do with Proposition 69. And and that it shouldn't be implied that 47 impacts 69 or impliedly repeals it or any portion of it without some mention in the ballot materials or in the text itself. So there's nothing that would have alerted the voters to the fact that they were changing the operation of the DNA database program, which has aided the investigation.
Are there no collateral consequences that are affected by Prop 47?
That's a very broad question.
Well,
it doesn't list any.
Okay, yes, I realize it's a broad question, but I think this is the kind of thing that falls into that category, right? Are you suggesting that we think about the phrase "for all purposes"? It seems odd to say, but it's a case-by-case inquiry. Despite the language, it says "for all purposes."
I think what the operative meaning of the misdemeanor for all purposes tracks the language of Section 17 and is a prospective looking kind of effect with respect to those kinds of circumstances. Because what you see here in 17 is, first you have a language of misdemeanor for all purposes is very unique to Section 17. It didn't appear elsewhere until you got to Proposition 47, and it's a well-understood phrase of criminal law. Trial courts deal with it every day. You don't have to look for it. As soon as you see that phrase, you know that you're talking about this sentence reduction from a prospective operation of a felony, to a misdemeanor. In addition, the two track each other very well, and so that is basically what voters would have logically presumed if they were tasked with knowing the law, which they are, that you're following the paradigm of Section 17. Both 17 and 47 have to deal with wobblers. 17 is the law of wobblers. And in the legislative analyst's description of what 47 does, it first describes what wobblers are and then describes, it's basically a short step from felony status to misdemeanor status in 47, because it goes through each crime and says this was a wobbler. So you're dealing with a law that deals with wobblers in the first place.
Let me give you a hypothetical, because I'm trying to take this discussion and anchor it in a very concrete example. Suppose the DNA Act were written in a slightly quirky way. It's the same in every way except that the DNA sample is collected 5 years after somebody is judged to have committed a felony. And this case involves conduct that occurred 4 years ago, or maybe it occurred at such a point where the collection is about to happen now, but it has not happened yet. For all purposes, that phrase, do you think that would prevent collection of the DNA sample?
So if I understand.
So in other words, if we take this from the retention context to the collection context and imagine that the DNA Act required that the sample be taken now, and this proceeding were about stopping that sample from being taken, does that language, shall be treated as a misdemeanor for all purposes, stop the collection of the sample?
So you've already been resentenced.
Correct, but the
Is that-
sample has not been taken.
Well, that controversial, at least in the briefs, language about a duty to provide samples under F, under that language, it does not matter. Notwithstanding any other provision of law, including a sentence reduction under 1170.18 or Section 17, you still have a duty.
Okay, so your position might be that F covers it, but then what, going back to Justice Liu's question, so what does for all purposes do? What are the all purposes that applies to?
It would be the same purposes, as what Section 17 applies for, because it's on the model of Section 17. So it has the language, it deals with wobblers, the language is presumed to mean the same thing, and just like 17, there are circumstances under each one where some of the sentencing is discretionary and some of it is mandatory. And so it almost lines up perfectly with Section 17, and that would compel the conclusion that what voters intended was it to follow that paradigm of 17 and resentence prospectively, not from that point going forward, your crime would be considered a misdemeanor for all purposes. That's what it means. It means a reference to Section 17.
Could I ask you, counsel, do you think significant privacy interests are at issue here?
No, I think that this court resolved that issue in People versus Robinson, that the collection of minimally intrusive DNA identification samples from a group of that has a reduced expectation of privacy as convicted offenders, that retention of that information in use-restricted confidential databases does not violate the Fourth Amendment. It does not.
It may not violate the Fourth Amendment, but I just asked, are there significant privacy concerns here?
Excuse me.
They could be outweighed by legitimate state interests, but doesn't DNA collection by its nature implicate very significant privacy interests? We don't willy-nilly give up our DNA.
No, but it's collected because you're a person with a reduced expectation of privacy and your identification information. The databank constitutionality is, and so the privacy argument is answered by the fact that the samples are retained in use-restricted confidential databases. It's like other identification information that is also retained in use-restricted confidential databases.
But do you think Robinson stands for the proposition that as long as the use is restricted in the database where the information is contained, that anybody who's arrested has no privacy interest in their DNA?
They have a diminished expectation of privacy, which is overcome by the state interest, and the retention of the samples in use-restricted confidential databases ensures that that remaining privacy interest is adequately protected.
I'd also go back to the very first question I asked, which is that, given the interest that you've put forward that the state very legitimately has with respect to crime solving and investigation and whatnot, you've said that you haven't made any argument necessarily that the individuals whose sentences have been reclassified are really relevantly different in the nature of their conduct than the class of people who would commit the very same offenses with the very same conduct going forward. You're not advancing that argument. You're not saying that Group A is different from Group B in some relevantly different way with respect to their underlying criminal conduct.
With respect
in other words, whatever scientists could tell us about the recidivism profile of Group A, namely those people convicted of felonies but were later entitled to reclassification of those felonies as misdemeanors under Prop 47, whatever an empiricist could tell us about their recidivism profile is no different than what they would tell us about the exact same people or a different group of people who committed the exact same crimes with the same conduct after Prop 47.
The interest...
You don't disagree with that, do you?
The state interest is the same with respect to collection of identification information that is the most accurate information that the state can retain. And so, yes, there was a decision to make to collect from only a group of people who had committed felony offenses. And the fact that they're now changed to misdemeanor offenses doesn't also change the state's interest in retaining that accurate identification information used to solve recidivist crimes. And so, in this sense, Proposition 47 and 69 share a common safety goal in reducing recidivist crime in neighborhoods.
What's the rationale? I go back to this very fundamental question. What's the rationale for treating them differently? I'm not pressing you on the point as to whether there are relevant, legitimate state interests that possibly could explain why you want to keep the DNA for the first group. My only question is, why are you treating the second group differently? Or what would justify that?
That again looks like the equal protection argument. And the equal protection argument is there was a rational basis for the retention of that information from the individuals that it is collected from in order to...
And the rational basis is what? That's costly to expunge the information, or?
Well, as a matter of fact, it is costly. So let's say you're looking at Proposition 47 and you're looking at the voter calculus for 47. Would that have changed? If voters knew that, there were 508,000 Proposition 47 samples that the state has collected, and it would cost millions and millions, and we've estimated it, what it would cost to expunge those samples. And so it would definitely impact the cost savings, from Proposition 47 to instead say, well, it's not going to be all of this savings for education purposes and for treatment programs, because a lot of it is going to go to to address another situation, which would be the costly expungement of 508,000 Proposition 69 samples.
Okay, so cost is a factor, and so the contention there would be that the voters could have thought that they didn't want the state to go to the trouble, essentially, of expunging. And yet, as the other side points out, and I don't know if you dispute this, it has never been the case, or at least not for a very long time, that misdemeanor convictions trigger DNA collection. In other words, whatever burden you're going to put people through in terms of collecting their DNA, the incursion on privacy, however limited you want to say that is, the determination by the legislature for a long time has been misdemeanor, that's not a serious enough thing to warrant this form of intrusion or surveillance.
It is not so much the seriousness of the offense. That's not at the base of Proposition 69 or really 47. 69 specifically says the limitation on the collection of samples pursuant to this chapter is for the purpose of facilitating it. We're going to make a cutoff with respect to the group that is collected for management and administration reasons, not because they're not deserving of some sort of collection. But that's an entirely different legislative judgment.
Well, that's just another way of saying that the state has priorities, and they've decided to prioritize the more serious offenders rather than the less serious ones. Isn't that just another way of saying the very same thing?
It is. It reflects a priority, but it doesn't reflect the extent of the state's interest in retaining identification information. So you have a defendant like in People versus Robinson who was collected for in error on a misdemeanor offense, but the law is very clear that, at least in terms of the legislative program for it, that it shouldn't affect, it doesn't give you a substantive right. It shouldn't affect, whether you can be prosecuted or convicted of that crime. And in fact, Mr. Robinson was found guilty of committing the numerous rapes and other serious crimes that he was ultimately convicted of those. And so that interest in that identification and in stemming recidivist crime in neighborhoods, that's an interest that's shared by Propositions 47 and Proposition 69. The Court of Appeal rulings in these cases are correct and should be affirmed by this court. Retention of DNA database samples after sentence reduction is consistent with both the goals of Proposition 69 and 47, given their shared public safety goals and keeping neighborhoods safe from recidivist crime. And Proposition 69 is a specific statute that governs DNA expungement and is effective notwithstanding any other provision of law, including Section 1170.18 that the legislature has now added properly to the DNA Act to clarify its reach. Thank you.
Thank you, counsel. And you have your full 5 minutes for rebuttal.
Thank you, Your Honor. As a preliminary matter, I would welcome the opportunity to provide a supplemental brief on the equal protection issue as to the circumstances under Section 299B. I will address that briefly. I don't see a rational basis for differentiating between people with reclassified offenses and the people, particularly the two sets of circumstances I discussed earlier under subdivisions B2 and B4. It is effectively and functionally the same thing.
Counsel, before you get into the constitutional stuff, let me just ask you a quick question on the statutory front. You had mentioned earlier that there was a remedial purpose in Prop 47 that you think cuts against not providing relief here on the DNA retention. And I just want you to just say a little bit more about that, because I think, one argument you could be making, but maybe this is not the argument you want to make, is that Prop 47 is partly about saving money and reducing imprisonment costs, and by not retaining this information, it is less likely that individuals who do recidivate will be caught, and so it will be less spent on their incarceration. But if that's not the argument, I'd like to know what you are.
I would prefer not to make that argument.
I figured, so I wanted to give you the chance.
So, as I discussed briefly earlier, the relief is broad temporally. It's people, so the stated respondents' assertion is this is a proposition about public safety and cost savings, even for folks who are not a danger to public safety anymore or costing the state any money, they can apply to have their offense changed to a misdemeanor. And again, the only conceivable purpose is to relieve them from the collateral consequences associated with having a felony conviction. They can petition through April of 2022. There's no temporal limit on how far back they can go, and they have a few more years to come to court to try to get their offense reclassified. Subdivision M states this section shall not diminish or abrogate any rights or remedies otherwise available to the petitioner or the applicant. That's pretty explicit. We want to provide broad relief. The amendment provisions, I think, are particularly instructive. They say, well, first, the statute says the act should be broadly construed. It may be amended only by 2/3 of the legislature and only if that amendment is consistent with and furthers the intent of the act. In contrast, the legislature only needs a simple majority vote if they want to reduce the penalties associated with any of the identified reclassified offenses. So there's nothing in the language of Proposition 47 or its implementing statute that gives any indication that the voters intended to constrict the relief available to people who successfully petition for to reclassify or to change their...
But isn't the opposite also true? That the language of Proposition 47, in the language of Proposition 47, the drafters failed to specify that reclassification authorizes expungement.
Yes, but they also failed to specify any other collateral consequence, and by that logic, the legislature is free to mandate that people with reclassified offenses continue to be treated as if they've been guilty of a felony for sentencing enhancements, for voting purposes, for licensing procedures. If the language is read that way, it's effectively transformed into these offenses shall be misdemeanors for all purposes except any which the legislature decides they shouldn't be anymore. And that's not what the proposition said. It said for all purposes but that one.
Thank you.
Counsel, can you speak to the cost argument related to the rational basis argument on the equal protection claim?
So it's our position that this is not a floodgate problem. The people who will be eligible for expungement under Proposition 47 will be people whose offenses have been reclassified. They have no independent felony that would require DNA submission.
But there's going to be a cost associated with the expungement process. And as I understood the argument the AG was making, that is or could be a rational basis for the distinction at issue here.
I'm not sure that I agree that the AG has presented competent evidence as to exactly what that cost will be.
Do we need to know the exact number as opposed to just there's going to be a cost? You're asking government to do something it wasn't going to do otherwise. So there must be some cost. We don't know what it is.
I think in order to determine whether it's a rational basis, we would need to know what the cost was. If it was...
Would the voters need to know about that cost? Because they were told Proposition 47 was going to reduce costs. And now we're adding a cost that will offset, theoretically, the reduction.
Again, I'm not sure that there's competent evidence before this court that that cost will offset the entire reduction.
No, I'm not saying it's going to offset the entire reduction, but some reduction. Some of the reduction, proposed reduction, however much that was going to be, is going to be less than the voters anticipated because they're going to have to pay for the expungement of these DNA samples.
And if cost reduction were the only stated purpose of Proposition 47, or one of the only ones, that would be one thing. But there's already a provision in Proposition 47, which is the petitions for resentencing, that will cost money. So to say that there can be no cost associated with this, or the voters intended that there be no cost, I think it is inaccurate because it clearly contemplates a cost. As to whether the voters were informed of that cost, no, but to the extent they weren't informed of the cost of any petitions to have the collateral benefits of these reclassifications attached to their cases. So I'm not sure that this court can say whether that's a rational basis without knowing what those costs actually would be. As Justice Pollock said in his dissent, the databank statute reflects the policy determination that persons convicted of less serious offenses are not required to contribute their DNA to the state's DNA database. Proposition 47 has moved people such as CB and CH into the category of people who are not required to provide DNA samples. We are requesting that this court enact the purpose of Proposition 47 and allow DNA expungement in their cases. Thank you.
Thank you, counsel. The matter will stand submitted. The next matter is the case of Eduardo de la Torre versus Cash Call, and for this matter we are happily joined by the Honorable Judith L. Haller, Associate Justice of the 4th District Court of Appeal. Except we're going to wait for just a moment. Just take a deep breath. And as you may have seen on our calendar, we are planning to have a brief ceremony in honor of the memory of Justice Arabian. Due to a small procedural glitch, we are not doing that at the beginning of the calendar. We are doing it at the end of the calendar, and we invite all of you to remain for that purpose if you are free to do so. Okay. All right, Mr. Straven, you may proceed.
Good afternoon. Madam Acting Chief Justice, and may it please the Court. The question certified by the Ninth Circuit and accepted by this Court is one of statutory construction. May an interest rate on loans of $2,500 or above be determined to be unconscionable by a court? We submit that the answer is yes. Since 1979, California's unconscionability statute, Civil Code Section 1670.5, has broadly applied to all contracts in California. Here, there is no express exemption from the unconscionability statute for loans of $2,500 and above. Instead, the legislature added a section as a result of the Attorney General's objection during the legislative process in 1985 that says unconscionability applies here. Section 22302 states that, quote, Civil Code Section 1670.5 applies to the provisions of a loan made under this division.
Counsel, does unconscionability apply for loans that are under $2,500?
Yes.
Why? Just explain that. Unpack that.
Because Section 22302 states that the unconscionability statute applies to the provisions of a loan subject to this division. Loans below $2,500 are loans that are subject to the division, as well as loans of $2,500 above.
Thank you.
In interpreting the relationship between the two sections, 22302 and 22302, the court will not nullify the language of one statute, here 22302, unless the two statutes are completely irreconcilable, clearly repugnant, and so inconsistent that they cannot be given concurrent operation. These two sections are not in conflict. There's no conflict between eliminating direct interest rate caps as a form of regulations on loans below $2,500 and still subjecting those loans to the unconscionability statute.
What is the difference between the two? So how could a suit alleging unconscionability avoid essentially imposing an interest rate cap, where the sort of primary basis for establishing unconscionability has to do with the amount of the interest rate?
So by way of answer, let me turn directly to the legislative history, because I think its chronology helps to answer that question. In April 1985, the bill, AB 447, was initially introduced and contained only 22303. In other words, the choice by the legislature to impose maximum rate caps only to loans below $2,500. The Attorney General expressly objected and sent a letter to the chair of the Assembly Committee and said, we believe that all low-income consumers who have loans between $1 and $5,000 need protection from exorbitant charges. The Assembly quickly responded. In 12 days, it added Section 22302. And that section is clear on its face as to what it says. Subsection A says, Section 1670.5 of the Civil Code applies to the provisions of a loan contract that is subject to this division, meaning all provisions of all loans subject to the division. Subsection B of that section said, a loan found to be unconscionable pursuant to Section 1670.5 shall be deemed to be in violation of this division and subject to the remedy specified in this division. So when it added those two subsections in 22302, the legislature responded to the Attorney General's concerns, amplified before this court in its separate amicus brief, and expressly subjected all loans subject to the division to the unconscionability statute.
So I guess what I'm asking is how do these two, I will assume that history and sort of what the legislative purposes that are reflected in the statute is all accurate, but how do these two statutes coexist, in other words? So what is the difference between an unconscionability inquiry that takes place with respect to Section 1670.5 under Section 22302? How does that sort of differ from the imposition of a rate cap?
So Section 22303 is the rate cap section, and it provides in subdivisions specific rate caps up to dollar amounts of loans under $2,500. And the last sentence of that statute says this section does not apply to loans of $2,500 or more. The legislature also enacted an alternative rate cap statute, that's 22304, and had another series of rate cap options for lenders. The last sentence in that alternative statute says the same thing as the last sentence of 22303. This section does not apply to loans of $2,500 or more. So the only thing exempt from the rate caps are loans of $2,500 and above. But it's only those rate caps which are specifically identified in those two provisions, 03 and 04. Now, further on to the legislative history, as quickly after the Assembly added 22302, the Assembly as a full body acted and passed the statute. Shortly thereafter, the Senate concurred and passed the statute. As part of the enrolled bill, the Department of Corporations told the legislature that while the bill lowered caps for certain loans, the bill was, quote, preserving the consumer protection provisions of all laws. After the bill was passed by the Senate, the author, Senator Voigt, sent a letter to the governor, Governor DeMaggio, about the bill. He confirmed the broad intent, explaining that, quote, 1670.5 in the Civil Code is incorporated by reference in both laws to provide a remedy for excessive charges. Again, that is consistent with the Attorney General's express objections to the bill as not protecting low-income consumers from exorbitant charges. Let me turn briefly to the doctrine of price unconscionability. Price unconscionability, as the merits briefs, the brief of the Attorney General of California, and the brief of the Associated Consumer Groups demonstrates, has been in place throughout the world for centuries. It has been in place in California as part of our common law fabric for more than a century. It was added specifically in 1979 by the legislature to be a statute that governs the contracts, all contracts in California.
It's a pretty big deal. I'm sorry, Nick. Unconscionability is a very big deal. And I mean, I gather that's the thrust of your argument, and it has very long roots. But I don't hear you arguing, I want to make sure I'm getting this right, that there is a clear statement rule that the legislature cannot abrogate or limit unconscionability unless it says so explicitly? Would it be fair to say that that's not what you're arguing, or is that in fact what you're arguing?
No, that would be part of my argument, if the legislature had responded to the Attorney General and had not included the unconscionability provision in 22302, cash call would be here as well as in the other courts arguing that the legislature had refused to subject these loans to the unconscionability statute, even though 1670.5 applies. Instead, it acted affirmatively to expressly add that statute to signify its clear intent that unconscionability to apply to all loans under the division.
Thank you.
In Purdue, this court said, and I want to quote briefly from the opinion, quote, 1670.5 is part of the common law governing all commercial transactions. The duty of good faith and fair dealing and protection against unconscionable contracts has never been thought incompatible with the free and competitive market. That's at page 943. So that's been the case since 1979 when the statute was enacted. That's what this court expressed when it decided the Purdue case in 1985. 6 years later, in Carboni versus Harrisbeed, the Court of Appeal held that an interest rate of 200% on a loan just under $100,000 was unconscionable and reduced the rate, the loan interest rate, to the default rate of 24%. Interest, it said, is the price of money lent. So the rate of interest is a key provision of any loan. Other statutes have followed Purdue and Carboni in other states, and we briefed extensively a number of those cases, including State versus B Investment in New Mexico, where the court, acting on a statute that is verbatim of 1670.5, ruled that loans with interest rates of 1147 to 1,500% on $300 loans were unconscionable and reduced the interest rate to the default rate of 15%. Courts in Wisconsin, Delaware, and New York have acted similarly. Let me talk briefly about Cash Call's signature loan product of $2,600, which is the focus of this litigation in this case, which has been ongoing now for almost 10 years. At the time that we got to the Ninth Circuit, 2014, Cash Call had moved for summary judgment. We had opposed the motion. There was a substantial evidentiary record, and the recitation of the facts and circumstances of Cash Call's $2,600 loan product are discussed in some detail with record cites in our opening brief. According to its CFO, Cash Call's signature loan of $2,600 with an interest rate beginning at 90% in 2008 was a unique product. During the class period in this case, which goes from July of 2004 to July of 2011, there was virtually no competition for that loan product in the California market. Cash Call targeted vulnerable low-income consumers with low FICO scores suffering financial distress, knowing that they would be trapped later on and having no alternative to borrow any money above below $2,600 because that was the floor that Cash Call set. The loan terms, interest rate, repayment terms of 42 months were not disclosed until the end of the loan process. Cash Call engaged in a very expensive, aggressive marketing campaign to sell these loans as it increased the interest rate from 90% to 96% to 135%, and now currently well over 200%. It increased the default rate, which during the class period was upwards of 40%. So the higher interest rate increased the default rate because the same low-income consumers who couldn't pay the loans at 90% or 96%, couldn't pay them at 135%.
Could I ask you a question that may go a bit beyond the narrowest form of the question that the federal court's asking here? Suppose we say that unconscionability is an available doctrine for these loans. Does that mean that a court applying the doctrine would essentially have to pick a number?
We have taken the position in this litigation, Justice Liu, that the court doesn't have to pick a number for a couple of reasons. Number one, it's not just determining whether the interest rate in isolation is unconscionable. It's deciding whether the interest rate coupled with the repayment term of 42 months or higher is unconscionable, judged against the totality of circumstances, which includes the evidence that I just referred to about cash calls, loan, product. But if the court decided among its range of remedies under 1670.5, under 17203 of the UCL, under the remedies specifically set forth in the finance lenders law, if it decided that it had to set a rate, then it would presumably receive expert testimony and decide, based on all the facts before it, if it decided that the loans were unconscionable, then it would decide a rate that could not be exceeded and presumably award restitution to members of the class based on that rate. But under 1670.5, one of the remedies is to void all the interest altogether because the loans were unconscionable from the date of the loan itself. That's one of the remedies that the court could look to in deciding whether or not to void all the interest. But in answer to your question fully, I think the court could look at what experts say is an appropriate rate for these types of unsecured loans in the market.
Thank you.
One of the cases that was mentioned for the first time in Cash Call's response to our amici briefs, and which was not cited at any time to my knowledge in the first 10 years of this litigation, was this court's decision in West Pico, decided in 1970. And in West Pico, this court said that where there are loans that are exempt from the usury rate based on the constitutional provision considered there, that constitutional provision trumps all common law restrictions. But, the court said, quote, unless the legislature so provides. So in 1979, 9 years after the West Pico case, the legislature enacted the unconscionability statute. That's an express statutory provision. It then reenacted it, in effect, when it added it to the finance lenders law 6 years later in 1985. That's an express legislative act that takes it out of the West Pico format. And the court in Carboni versus Aerospeed, which I mentioned before, also discussed a case prior to West Pico decided by a court of appeal called People's Finance, decided in 1965, said it was wrongly decided, but said even if it wasn't, if the legislature acts expressly to include a statute that makes the loans non-exempt, in other words, non-exempt from protections, then that's a sufficient legislative act, and that will be honored. Unless the court has further questions, I will reserve the rest of my time.
Very well. Thank you, Mr. Zerdman.
Good afternoon, and may it please the court. The response to the Ninth Circuit's question is no. The interest rate on a loan governed by Financial Code Section 22303 cannot be unconscionable under Section 22302. When the legislature enacted Section 22303 in 1985, it removed interest rate caps on loans of $2,500 or more. It created an express exemption from existing interest rate caps. And this was not an isolated act. Previously, the law had imposed caps on interest rates below $10,000. The legislature lowered that cap in 1984, and then a year to $5,000. And then a year later, in 1985, it lowered it again to $2,500, where it has stayed. The legislature, in doing that, was acting under its exclusive authority to regulate usury under the Constitution. The legislature's purpose was to allow the market to dictate interest rates on loans of $2,500 or more. The legislature did not intend to allow courts to make ad hoc, after-the-fact determinations of whether a lender's loan above $2,500 was unconscionable.
Counsel, I think there's a logic to your argument described in the structure of the statute, and I do think that that argument would have even more traction, perhaps, if the legislature had not included unconscionability in this sort of scope of statutory provisions as well. So what I wonder about, and maybe you have an answer to this that will help me, is I gather your argument is essentially unconscionability applies, but not with respect to interest rate terms. It applies in other respects. So if we're dealing with a loan of $2,500 or more, there can still be some claim raised that it's unconscionable, but there can be no remedy that goes to the interest rate. Is that fair?
That's correct. That's accurate. That is our position. And
then here's my question. It is perhaps an odd way to write a statute to include unconscionability, to effectively do so this way if the goal is to essentially cleave off a chunk of unconscionability and remove it from the traditional scope of the doctrine.
I think you have to look at Section 22302 and look at what the legislature did. And respondents focus only on subsection A, where they say unconscionability is going to apply to loans that are subject to the finance lender's law. That's all they focus on. The real key to Section 22302 is subsection B. And that's the section that says that loans that are found to be unconscionable will be, quote, subject to the remedies of this division. And so what that does, very importantly, is unconscionability had traditionally been only a defense to contract enforcement, a defense that a party could raise to the enforcement of the contract. By putting 22302 and A and B in, what the legislature does is says, no, if you lender engage in unconscionable lending practices, the Department of Business Oversight can take your license. The Department of Business Oversight can fine you. The Department of Business Oversight can suspend your license. Subject to licensure. That's what is said in the Legislative Council's digest when they're describing what happened, what 22302B is about. And that's really the key to 22302B. How the statutes work together, that's the key to answering the Ninth Circuit's question. How do they work in tandem? And our position is, number one, Section 22303 deals specifically with interest rates. Number two, 22303 creates an express exemption on the interest rate caps of loans of $2,500 and above. Section 22302 makes unconscionability subject to the remedies of the division, makes it a regulatory violation. Section 22303 is the more specific provision dealing with interest rates. Section 22302 is a general provision applying to all contracts. Section 22303 is the specific provision dealing with interest rates. The specific governs over the general. It's that basic proposition, and it's that is why an interest rate that's governed by 22303 of $2,500 or above, not subject to an interest rate cap, cannot be unconscionable under Section 22302. Now, we used to agree, respondents and cash call used to agree on the question of whether the specific or general controlled. In their briefs at page 10, they took the position that a loan in 22303A through D, one where the legislature has specifically set out the interest rate, the maximum interest rate that could be charged. They took the position that that rate is specific. The statute is specific as to those loans, and therefore 22302 doesn't apply. Page 10 of their brief, that's the position they took. That's not what they said here. And the position they're now taking, that 22302 applies to any interest rate, creates a tremendous conflict. Because under subsection A, the maximum rate that could be charged would be 30%.
Is it enough for you to win to argue that because the legislature specifically addressed interest rates in 22303, then interest rates really are not within the scope of the unconscionability analysis in 22302, or do you also have to persuade us about this remedy point you were making just now? Because I see your remedy point, but I wonder if that's a separate argument or if you think that's really integral, that, you know, the Department of, that essentially there's some kind of regulatory remedy that is the exclusive, I gather, is your argument, remedy for unconscionability?
That's correct. That's what the legislature did in 22302. So in figuring out how the statutes work in tandem, you sort of have to look at both of them and see what one did, what the other did, and then how you can harmonize them and how you can prevent a conflict. And the reason that there's a conflict, again, if you have a rate that's specifically authorized, so under subsection A, a 30% rate is permissible for loans under $225. 30% rate is permissible. So a lender goes out and makes a loan at 30%, and the borrower challenges and says, that's unconscionable. That's horrible. How could you charge such a rate? It goes into court, and the lender says, I'm allowed to do that under the statute. Under the position the plaintiffs are advocating now, it says, no, that still can be unconscionable, even though the legislature has expressly permitted it. And it's no different when you go to the loans above $2,500, because what the legislature there has done, again, is created an express exemption. And our interpretation that this is an express exemption is consistent with how the California courts, including this court, have interpreted similar language and similar provisions in the financial code. Mr. Sturdivant mentioned the West Pico furniture case. That is a case involving a different section of the financial code. It was the personal property brokers law. And that law, similar to the finance lenders law, established rate caps on loans of certain amounts. There were two specific sections that limited the rate caps on loans below $5,000. There was a general catch-all exemption section, section 22053. That section said, similar to the last sentence of actually identical to the last sentence of section 22303. This section the following sections do not apply to loans with a bona fide principal amount of over $5,000. Two of the sections that were listed in that statute, in that express exemption statute, were the interest rate statutes. So this court interpreted that language to say that does not apply language creates an express exemption. It was a statutory construction decision that this court made to say does not apply, creates an exemption. What the legislature was doing there was saying that loans above $5,000 have no interest rate cap. The Rasinger case, which we also cite, the People's Finance case, and the Coronet case, same holdings under similar language in the financial code, where you had interest rate caps below a certain threshold, no interest rate caps above that threshold. The legislature expressly exempted certain sections. The sections that were exempted were the sections dealing with interest rate caps. In all of those cases, the court says that language is establishing an express exemption. So clearly what we have here under section 22303 is that express exemption. It's not that it's irrelevant, as they argue in their brief. It's the legislature taking a specific position on interest rates and what the interest rate can be charged under those particular
Let me
loans.
assume for a moment that I accept your licensure and remedy argument. Would it be acceptable for the analysis of unconscionability on a loan, $2,500 and above, to include the interest rate in the sort of generalized inquiry about whether unconscionability has arisen, in addition to procedural issues and other contract terms? Or is your position that in no way can the interest rate even enter into that calculation? You see what I'm saying? Like leaving aside the issue of what is ordered as a remedy.
No, the interest rate cannot be considered substantively unconscionable. So it wouldn't...
But could it enter into an analysis of whether a contract, which includes not only an interest rate but many other provisions, is unconscionable?
No, the focus would be on other provisions of the contract as to what could be considered unconscionable because of the legislature's decision to exempt those loans from interest rate caps.
Doesn't it, sorry, just to follow up on that a moment, isn't it conceivable that the legislature might perceive a difference between setting an across-the-board rate cap that applies based solely on the amount of the loan and nothing else about the loan versus permitting some consideration in a more fact-specific manner of an interest rate, along with, other factual details about the manner in which the loan was concluded and the other provisions that might bear on an unconscionability analysis? Isn't that a distinction that the legislature could have drawn?
I think what's important to understand about this case is that this case is not about those other things. The way the case stands now, the case is only about the interest rate. It's only about that number. And that is in the district court's certification order, which is at 278 FRD 579. There were many, many theories raised in this case, and the only one that's left is this one that's based exclusively on the interest rate. And they did argue, and they did have a claim, an unfairness claim under the UCL. They also had a claim under 10 CCR section 1452, which deals with underwriting and taking into consideration the ability of a borrower to repay the loan. On certification, the court rejected class certification as to those claims. So now what we have, and the question that the Ninth Circuit is asking for help on, is what to do when they challenge the number and only the number. And it absolutely creates a conflict because in response to your earlier question, I think, of Mr. Sturtevant, Justice Kruger, the court has to take a position on what the interest rate is if there's a challenge on unconscionability. It has to do that because these are loans. And everyone knows a loan carries a rate of interest with it. And that's not just my argument. Carboni, the case that they cite for this proposition that unconscionability is applied routinely against interest rates on loans, the court there affirmed a trial court decision that modified the loan. It set an interest rate. It said 200 doesn't work. We're going to set it at 24. That's the rate. B&B Investments, the New Mexico case. Same thing. The New Mexico Supreme Court is explicit there saying, no, we are not going to prohibit the lender from collecting any interest here. We're going to set the rate at the default statutory rate. So they have to set an interest rate, a court, in doing this. And this won't be the only case. As we see, the amici on behalf of Cash Call, the California Finance Lenders, 60 lenders doing the same types of loans. All assuming, in this market, all assuming that what they're doing is permissible because there's no interest rate cap. And so they're making underwriting decisions, business decisions, based on the cost of making these loans. And the reason the loans are so expensive is because they're risky. A 45% default rate as to Cash Call, that's risky. That's risky. And if a court gets in after the fact and says, well, I understand that you priced according to what you thought the risk was going to be, but your interest rate should be 50%. Cash Call can't continue to do business that way. And these other lenders can't continue to do business that way. The balance that the legislature struck back in 1985 has benefited consumers. It has increased access to credit. That's one of the purposes of the finance lenders law, to increase access to credit. And you can see it in the DBO's own reports. We quote in our brief from the 2010 report of the DBO, where there were, I believe, about 35,000 loans made that year, above $2,500 with interest rates of above 100. Amici cite from the 2016 report, where there were 400,000 loans during 2016, between $2,500 and $4,999. 60% of those were above 100% APR. Credit is increasing, access to credit is increasing. That's part of the purpose of the finance lenders law. That's why the legislature struck the balance that it did. If courts come in after the fact, it eliminates that balance and it reduces access to credit. And that's not just an abstract argument. Because what we've seen, the legislature is continuing to look at interest rates and continuing to look at rates for the lower dollar loans. And this is the pilot program that we discuss and that Amici discuss. Under the pilot program, the legislature said, we're not seeing enough loans under the interest rate caps that exist under 22303A through D. There's not enough lending happening. So what are we going to do? We're not going to lower, or we're not going to reimpose an interest rate cap on loans above $2,500. We're going to let lenders charge higher interest on those lower dollar loans to try to encourage them to enter that market. So that's what the legislature is doing now, and that started in 2010, and that pilot program has been amended twice since then, as the legislature continues to tweak and set the economic policy of the state. And it's the legislature that's supposed to do this. And there's an implication, not an implication, it's a strong argument again and again and again why they cite all these unconscionability cases. Now, if you look through all the record, I think in California you have 2 unconscionability cases dealing with the interest rate on a loan. You have People's Finance from 1965, and you have Carboni in 1992. In Carboni, the court there has that quote that we bring out again and again, where they say, we are, to the effect of, we are surprised that we have not found a single case dealing with applying the unconscionability doctrine to a claim that the interest rate on a loan is simply too high. That is not how the court has looked at the legislature. It's the legislature that is supposed to set interest rates. In the Carter versus Seaboard Finance case, this court held that the Commissioner of Corporations did not have the authority to contravene a legislative decision imposing interest rate caps on loans below $300. Again, this was a financial code section. It was dealing with pawnbrokers back in the 40s. The Department of Corporations said, we're going to take that cap that you've applied to loans under $300 and we're going to apply it to loans above $300. The court said, no. It is the legislature under the Constitution that has the power to regulate interest rates under the usury statute, to define exempt classes of people. That's what the legislature has done in the finance lenders law. The Matalich case versus Marlowe Investment is another case from this court where the court again emphasized it's the legislature using its power to regulate usury that deals with interest rates. So there is not this long tradition of courts getting involved and making decisions and saying this rate is good, this rate is bad. That's not.
Is there any limit at all to the principle? So you've heard the hypothetical about the $2 million annual percentage interest rate.
And so my response to that extreme hypothetical is under the statute, the way it's drafted, yes, that rate would be permitted under the statute. And so, but I need to explain why that hasn't happened,
but is that
why that couldn't happen, and why it wouldn't happen. And so it hasn't happened. 33 years, the rates in question here, these are unquestionably high interest rates to people with good credit. But these are subprime borrowers. But if you compare the rates that are at issue here, 96% and 135%, they are significantly cheaper than the rate that the legislature expressly permits on payday loans. The legislature expressly permits APRs of up to 350%. That's the average APR in California on a payday loan. The other types of loans that may be available to people with poor credit, things like tax refund anticipation loans, auto title loans, pawn loans, the interest rates for the cash call loans, 96%, 135, are either comparable or even less than those types of loans. So it hasn't happened. Why wouldn't it happen? Because the market regulates these interest rates, and because lenders are required to disclose their rates. Lenders are required under Truth in Lending Act, under federal law, and also under the Finance Lenders Act. There are express disclosure requirements on lenders. You can't misrepresent your rates. So in a freely competitive market, if someone is out there advertising, come get my 1,000% loan, that lender's going to be out of business.
But I guess, just to be clear, your argument really is profoundly statutory in the sense that you are not arguing that unconscionability doctrine in general, however imprudently, reaches this set of facts. You're just arguing that, particularly just given specifically how the legislature decided to put this statute together, then unconscionability is sort of cleaved and only a piece of it is available and it doesn't go to interest rate.
That's correct. That's correct. That is correct.
Counsel, if in fact the determination that a different statutory interpretation is taken and the answer to the question is yes, unconscionability can apply, how would you envision the nature of the evidentiary hearing before the district court in terms of what would be relevant in determining whether or not the interest rate is unconscionable?
Well, we saw in this case, for example, the plaintiffs, how they were lining up the case. They had a psychologist that they wanted to provide expert testimony to explain how borrowers are unsophisticated and don't understand their loan disclosures. They had a lawyer who was going to argue about unconscionability law. They had an accountant. And not surprisingly, we had experts on the other side. And so the problem that you'd have is exactly the problem that this court identified in Harris versus Capital Investors. Every one of these cases would devolve into a battle of the experts. And it would be up to the court to decide, yeah, in this case, I like that expert's view, and I'm going to hold that a 75% rate is the maximum rate you can charge. Some other judge says, no, 96 is fine. So it becomes a battle of the experts. And really, it's up to the creativity of lawyers to determine who they think can convince the court that their view of the appropriate interest rate is correct. The B&B investment case that is cited and very heavily relied on by...
Counsel, excuse me for just a second. If it's a matter of experts saying what interest rate is appropriate, is that what we would be looking at? Or would you be looking at all of the factors as to the market in terms of why these kinds of rates are there, the need for them? Would those be relevant considerations?
That would go into the pricing question. So yes, in terms of if you look at the factors that the court set out in Purdue for determining the unconscionability of the bank fee in that case, looking at the rates that are charged in the market would be a relevant factor, would be something you'd have to look at. You'd also have to look at the lender's cost, the cost structure, and examine that and say, are you spending too much money on advertising? And if you spent less money on advertising, could you lower your interest rate? So it would be that kind of inquiry, expert-heavy inquiry. As I was saying, the B&B investment case, that would have been decided the same way in California. Not under unconscionability, because if you look at what was happening in B&B investments, and this is exactly the point that I make about why these extreme circumstances can't happen in California. That lender in B&B Investments was misrepresenting. It was falsely advertising the rates that it was charging. It advertised that the rates were 50% off, and all that meant was the first payment was 50% lower than all the others, but that was what it advertised. And it also told its loan agents to misrepresent how much the loan costs. And it told its loan agents, don't show the borrower the amortization schedule. The amortization schedule is the schedule that shows how many payments you have to make. That's what happened in B&B Investment. That is illegal under California law. That's illegal under the Finance Lenders Act. So without regard to the interest rate, you still have the ability, either an individual plaintiff in that circumstance or the department in that circumstance. If the department saw a lender doing that in California, the department could come down hard on that lender, could impose fines on that lender, $10,000 per violation, which would be per loan, every time they did that, every time they tried to pull that. And it could, for a willful violation, it could take their license. And it also has the ability to give restitution on behalf of the victims. So in the situation you posit, it hasn't happened. It wouldn't happen because of the market forces and disclosures. And it couldn't happen absent some other violation of the law that would be actionable that would prevent the lender from doing that. This is a question of statutory interpretation, and it is important to remember the narrow question that the Ninth Circuit has posed based on the status, the procedural posture of the case now. The only question is whether the interest rate alone can be unconscionable. That's the only question. And the question is a question of statutory interpretation. The statutes themselves, we think, clearly set forth that there is no limit on interest rates above $2,500, that the unconscionability statute is a regulatory statute not intended to permit courts or even the department to police the interest rates. It deals with other provisions. And the specific statute, 22303, governs over the general. With that, I would ask you to answer the question no. Thank you.
Thank you, counsel. Mr. Sturtevant?
I think much of my brother's argument ran far afield of the narrow statutory construction he presented it in his summation, but I want to respond quickly to the several of the points that he made. First, in the colloquy with you, Justice Cuellar, he talked about the subsection B of 22302, but he only quoted half of it. The first half of subsection B says, a loan found to be unconscionable pursuant to section 1670.5 of the Civil Code shall be deemed to be in violation of this division. And that determination will be made by a court, because it's the court that's authorized under the unconscionability statute to make that determination. Then he quoted the rest of B, which gives the department some authority to impose remedies authorized by the California financing law. But the first half goes to what a court can do. Second, he read from page 10 of our opening brief. And I leave it to the court to read that page. But the examples we talked about on that page dealt with the interest rate in isolation, not whether the interest rate could be considered together with all other provisions in the loan, together with the facts and circumstances, or as the court said in Purdue, the custom, purpose, and effect of the loans, which is always germane to determining whether something, a loan or another contract, is unconscionable. With respect to the class certification, there are two common ingredients. The amount of the loan, $2,600 and above, and two, interest rates of 90% and above. Those are the two common ingredients that unite all class members in the case certified, in this case, by the district court in 2011. His argument that the sky's the limit really asked this court to put its imprimatur on a situation in which I have argued already about what the legislature did, when it did it, and why it did it. The sky's the limit means the lid's off. Forget the loan at 1,500% in New Mexico. Forget the 200% in the Carboni case, which Justice Chin considered as a member of the panel in that case when he was on the Court of Appeal. You could go to 1,000,000%, and unless the department came in and said, nope, can't do that, no court in California could come in on those loans, $2,600 at 1,000,000% for 3.5 years or 4 years and say, that's too much. In isolation with the interest rate or together with the other provisions. I can't imagine this court putting its imprimatur on that. I can't imagine this court saying that when the legislature acted affirmatively in 1979 to make the unconscionability a part of our statutory system, when 6 years later it added that statute expressly into the finance lenders law, that it would say that with respect to the loans that the Attorney General was expressly concerned about, all loans up to $5,000, the sky could be the limit. He talked about this court's decision in Carter. If you go back and read that decision, the court said the legislature has the power to enact a provision to restrict the loan terms. So in each of these instances, I believe the cash call is wrong. The court should answer the certified question in the affirmative. The legislature added the unconscionability statute to the California's Lenders Law in 1985 and authorized courts to determine whether all provisions of all loans subject to the division were unconscionable if challenged. California's unconscionability statute governs all contracts and is resolved by courts on common understanding, on common principles, repeated again and again by this court in all of its recent arbitration decisions. And it looks at all of the conduct and all of the circumstances and all of the provisions surrounding the loans at the time they are made. If this court answers the question in the affirmative, we're poised to go back to the district court and prove that the loans at issue in this case are unconscionable. Thank you.
Thank you, counsel. The matter will stand submitted. Ladies and gentlemen, as our calendar notes, it is our intent to note the passing of our colleague, Justice Arabian, and to acknowledge his remarkable service. And for that purpose, I turn the proceedings over to our colleague, Justice Chin.
Thank you, Justice Corrigan. Good afternoon, ladies and gentlemen. Because of the passing of her mother last night, the Chief Justice has asked me to preside over this special session of the court. We meet today to honor Justice Arabian, who served with great distinction as an Associate Justice of this court from February 3rd, 1990 until February 28th, 1996. He passed away in March after 4 decades of service to the judicial branch. For the record, I would like to introduce the members of the court. To my left is Justice Carol Corrigan. Next to her is Justice Goodwin Liu. Next to him is Justice Leon Kruger. To my immediate right is Justice Mariano Florentino Cuellar. To his right is Justice Judith Howler from the 4th District Court of Appeal, sitting pro tem. We, of course, await the governor's appointment of a new justice to fill the seat of Justice Catherine Werdegar, who retired August 31st, 2017. On behalf of the court, I want to express our gratitude for Justice Arabian's long record of public service to the people of California. It is fitting that we are holding this special session honoring Justice Arabian in Los Angeles, in the courtroom where he served as a justice for the 2nd Appellate District before being elevated to the Supreme Court. Justice Arabian's service was remarkable not just for its length, but also for the fact that he served at every level of the court during his career, at the Los Angeles Municipal Court, the Superior Court of Los Angeles County, the 2nd Appellate District Court of Appeal, and the Supreme Court of California. Justice Arabian was the son of Armenian immigrants whose family members were killed during the Armenian genocide. Justice Arabian served as a paratrooper in the United States Army before earning his law degree from Boston University. I often commented to Armin, why would somebody jump out of a perfectly good airplane? He never gave me a good answer. He began his law career as a deputy district attorney in Los Angeles and spent nearly a decade in private practice before being appointed to the municipal court by then-Governor Ronald Reagan. As a Superior Court judge in 1973, Justice Arabian made history by refusing to give a mandatory jury instruction to consider testimony of an alleged rape victim with caution. The state Supreme Court later struck this instruction down. As a justice of the Supreme Court, he authored nearly 100 opinions, a substantial number for his 6 years on this court. Justice Arabian authored the majority opinion in the landmark case of People versus Enges and expanded the limits for criminal culpability in rape cases. At the time, these decisions were groundbreaking and courageous and have become an important part of Justice Arabian's legal legacy. Now, I've told you that Justice Arabian retired February 28, 1996. I was appointed to replace him 1 day later, March 1st, 1996. Different time, different place, different governor. Six weeks before I was sworn in, I was at a meeting of the Appellate Committee of the Judicial Council. Justice Marv Baxter, who retired from this court several years ago after serving 24 years, was the chair of that committee. When I went into the room, Justice Miriam Vogel, who's retired from the 2nd District Court of Appeal, motioned to me and said, "Ming, come and sit by me. I have some hot gossip for you." I'm always up for gossip. So I sat down next to Miriam and she said, "Ming, I bet you that the governor will call you within 2 weeks appointing you to the Supreme Court." I laughed. I said, "That's a good bet," to myself. First of all, I don't expect to hear from the governor at all. And number two, it certainly won't be within 2 weeks. Justice Arabian isn't retiring for 6 more weeks. The first time I was considered for this court, it took the governor 8 months to make the appointment. So I thought this was a sure bet. No sooner did Marv call the meeting to order, and a hotel employee came in with a tray with a note on it and gave it to me. It was the call from the governor. Now, I later called Marv and told him that I was really sorry that I didn't come back to the meeting. Marv said, "Did you get the call I think you got?" Marv was the first one who found out that I was going to be appointed to replace his good friend, Armin Arabian. Just an aside, I called Miriam Vogel and I said, "Miriam, I know you won the bet, but I don't remember how much we bet." And Miriam said, "Ming, you owe me $10,000. Well, she reached a little high. Marv Baxter wanted to make sure that I expressed his regret for not being able to be here personally to honor his good friend Armin Arabian. But Marv and Jane have a good excuse. They are at their youngest granddaughter's high school graduation as we speak. Marv wanted me to tell you that Armin was not only a good friend, he was an experienced and outstanding jurist who made very important contributions to the development of law while he served on so many different courts in California. I've told you that I succeeded Armin Arabian, so my name is linked to his in many ways, and I'll tell you about a couple of them. One of them is in each of our chambers there's a plaque that lists each of the occupants of that office. I will always be proud that my name follows Armin Arabian. I am actually still sitting in his chair at his desk. I want to tell you, I told my colleagues after I spoke at Armin's memorial, I told them a story about a former client of mine. It was a client who happened to bring a case to the California Supreme Court and lost. Justice Arabian drafted the dissent, joined by Justice Baxter. When I was appointed to the court, my client, that was a chain of convenience stores, hundreds of them throughout California, had bags printed. And on the bag it said, "Congratulations to Justice Ming W. Chin on his appointment to the California Supreme Court." Can you imagine going into a convenience store and finding this bag? At the bottom of the bag, they also said, "And we congratulate Justice Armin Arabian on his well-deserved retirement." I'll tell you one final short story about Armin. Right after my appointment, I came to Los Angeles to give a speech to the Southern California Chinese lawyers. At the beginning of the speech, I introduced Armin, thanked him for deeding his seat on the Supreme Court to me, and I also told the crowd that Armin was going into private judging, and I gave out his telephone number. It was 1-800-ARABIAN. Armin immediately stood up, came up to the stage, and gave me one of those Arabian bear hugs. I'll never know whether it was because I thanked him for my seat or gave him the number of his private judging to 500 lawyers. The second thing that Justice Arabian gave to me is probably the most valuable. Armin left me with two of the most outstanding attorneys I have ever met. They were on Armin's staff. They have been on my staff ever since. Jay Cummings was only on Armin's staff for about 3 months, and my current chief of staff, Blair Hoffman, served on Armin's staff for many years. Because of that, we have asked Blair to give us his remembrances of Justice Armin Arabian. Blair Hoffman.
Thank you, Justice Chin. May it please the court, it's been many years since I had a chance to say that to this court. Associate Justices and Acting Chief Justice, thank you for the opportunity to speak today. It is an honor and a privilege to be able to comment on Justice Armand Arabian's legacy from the perspective of one of his staff attorneys. I treasure the 6 years with him. They were exciting times. As Justice Chin surveyed, Justice Arabian was a very fine man. He was a loving and devoted family man. He adored Nancy, his wife of over 5 decades, and his son Robert and daughter Allison. He was a very proud American, but he was also tenaciously proud of his Armenian heritage. But with your permission, I would like to focus on what I personally know best of him, his role as a Supreme Court Justice. Sometimes in proceedings like this, I've heard the speaker extol the honoree's humility. Well, I've decided to take a different approach. As you know, Justice Arabian could be flamboyant. It was in his nature. He reveled in it. Some of his opinions show it, although they also show his passion and his insight. Once in an opinion involving whether California could prevent tobacco companies from advertising cigarettes to children, he wrote, "It is now asserted that plaintiff's effort to tread upon Tobacco Road is blocked by the nicotine wall of congressional preemption." That's Mangini versus R.J. Reynolds Tobacco Company, 1994. He, of course, rejected the assertion and held that the state could protect children from cigarette advertising in its role as parens patriae. In a dissent, he once wrote that in enacting Proposition 8, the electorate did not intend an unforeseen trip into the muddy fen of witness bashing, character assassination and witness bashing. That was People versus Wheeler, 1992. And who could forget his dissent in Narstedt versus Lakeside Village Condominium Association, 1994, where he chronicled the importance over many centuries of cats and dogs as human companions, invoking sources ranging from Homer's Odyssey to Albert Schweitzer. But as someone who worked with him on a daily basis as his staff attorney, I knew of Armand Arabian far more than just his flamboyance. Have no doubt about it. Justice Arabian was also rock solid. He knew the law, he studied the law, he cared passionately for the law. I remember clearly one time he walked into my office holding a counter memorandum from another chamber that he disagreed with, his ears steaming. He looked at me, and before I even had a chance to read it or even know what it was about, he told me, "This will not stand." And it didn't. Working closely with me, he soon circulated a dissenting counter memorandum that gained majority support, and he eventually authored the majority opinion, reaching the result he believed was correct. As Justice Chen talked about, I'm going to go into also, there was one area of the law that has penetrated everyone's consciousness today, but Justice Arabian was ahead of his time. He hated and he crusaded against all forms of sexual misconduct. As Justice Chin mentioned, as a trial judge, he famously refused to give a jury instruction that was then required in rape cases. Specifically, that a rape charge is easy to bring, but difficult to defend against, even if the accused is innocent, and therefore the jury is required to view with caution the testimony of the complaining witness, who was described as the female person named in the information. This court granted review, or to use the terminology then in use, this court granted a hearing. In its ultimate opinion, explained that Justice Arabian refused to give the instruction because he believed it demeaned the victim. The opinion vindicated him and replaced the former instruction with a new, more balanced one. In Mary M. versus City of Los Angeles, 1991, this court held that a city could be liable in tort when one of its police officers raped a woman he had stopped or detained while on duty. Justice Arabian authored an eloquent concurring opinion to, as he put it, reflect on the incremental advance today's holding represents in the effort to redress the historical imbalance between victim and accused in sexual assault cases. He wrote that rape, along with other forms of sexual assault, belongs to that class of indignities against the person that cannot ever be fully righted and that diminishes all humanity. Discussions with staff, including me, during the time that opinion was written, left no doubt how strongly and sincerely he believed that. Despite his strong personality, Justice Arabian also fit in nicely with a court that, after a few turbulent years, was and remains remarkably collegial. Almost by definition, Supreme Court justices have strong views. Justice Arabian certainly did, but he could disagree without being disagreeable. His lively sense of humor certainly helped, and his humor could be, and often was, self-deprecating. For example, he would have laughed uproariously at my comment that I decided to take a different approach than to stress his humility. I know he would have laughed because he in fact did laugh when I humorously made a similar comment to him one time in person. He knew that humility might not rank real high among his primary attributes. Justice Arabian often, while on the court, would walk the hallways, greeting other staff attorneys and discussing the important cases of the day, and occasionally lobbying for his position. He loved being a judge, and his energy and keen mind were the hallmarks of his time at the court. I also know from personal experience that he was kind and considerate and supportive to his staff attorneys, who he always valued. Justice Arabian was one of a kind. We will all miss him. Thank you.
Thank you, Mr. Hoffman, and thank you, Justice Chin, for your collectively quite gracious remarks. The clerk of the court and the reporter of decisions are directed to see that these memorial proceedings are spread upon the minutes of the court. And with that, we are in recess until 9 a.m. tomorrow morning. Thank you.
All rise. Court is in recess until 9 a.m. tomorrow.